break. I'm going to be speaking about immigration. Michelle and myself do a lot of training sessions for employers and startups here in the UK. At times, immigration is always the last thing that employers think about. Immigration should always be at the forefront of your mind. It is very political at the moment. We have a government that is tasked with reducing net migration from the hundreds of thousands to the tens of thousands. That is a manifesto commitment. Net migration at the moment is running at 350,000 people a year. That is the size of Birmingham coming into the UK every year. David Cameron says, no ifs, no buts, it will be achieved. Now, as part of that is a reduction of numbers on skilled workers, highly skilled workers, and partners of British citizens and settled people. And Theresa May announced yesterday that if you fall in love with someone from outside the European Union, the criteria by which you, your partner, will be allowed to remain in the UK is how much you earn and how much savings you have. If you do not meet a strict income level, you will have to leave the country of your birth and find somewhere else to live. That's good news for lawyers like me, because we have the Human Rights Act, which is a right to a family and a private life, and our government, no matter what they say, cannot restrict your right to who you fall in love with and where you have your private and your family life. So watch this space. Bit of background for you. We are members of the European Union until such time as we get a vote to pull out. That means that 27 countries, the people can come to the UK and work without restriction. If you're self-employed, you can also work here. If you study, you can also study. And if you're self-sufficient and have comprehensive health insurance, you can come here and do absolutely nothing. We have what are called A8 nationals. They were Polish, the Czech Republic, Slovakians, for example. They were subject to what was called the Workers' Registration Scheme, where they had to get permission to work in the first month of employment. That derogation under EU law has now finished. We were allowed to derogate from that for 11 years, and that is now closed. A2 nationals, those are Bulgarians and Romanians. We do have a restriction. They are considered just like third country nationals, and if you wish to employ a Bulgarian or Romanian, you actually have to seek permission for them to work for you. Everyone else needs work permission in the UK. So in 2008, the government introduced the points-based system. We have a number of tiers. Tier 1 used to be called highly skilled. They're now highly valued, i.e. how much money do you bring into the UK. Tier 2, your skilled workers. Tier 3, unskilled workers. That has never been opened because there are a vast amount of unskilled workers within the European Union and the UK. Tier 4, students. Tier 5, temporary workers. There are also a number of non-points-based system categories as well that are still open. So what are high-value migrants? Tier 1 general, that has now been abolished as the government felt that it was being abused by people who were coming to the UK without a job offer. Payslips were being created, companies were being created, and people were paying them money themselves. That has now been abolished. It has been replaced by a scheme called exceptional talent, and you have to get an endorsement by a government body in the science, humanities, engineering and the arts. From the last Freedom of Information request we did, only 19 people out of 1,000 got a visa under that category. We also have an entrepreneur category. If you want to set up as an entrepreneur in the UK, this is one of the easiest ways to get into the UK. All you need to show is evidence that you have access to £200,000. Now that can be from a friend, a family member, a third party, and it just has to be freely transferable to the UK, and a 3-year visa will be issued. The conditions of that visa is after year 2, you have to create 2 jobs, and those jobs must be to resident workers. So they have to be people who are settled here, i.e. European Union citizens, British citizens, or people who are third country nationals with permanent residency. You also register as a director or self-employed within 3 months, and you can also be an entrepreneurial team as well. If you have £1 million, you can come to the UK and you can work unrestricted. If you have 5 million and 10 million, your path to permanent residency will be reduced. If you have 10 million to invest in the UK, you will get permanent residency after 2 years. The downside is that you have to invest 3/4 of it in government bonds, which will give you a 0.00% return, but at least it's safe. And if you're a Russian oligarch, you can come here and your partner can go shopping and you get permanent residency after 2 years. And the prize at the end of 5 years is a British passport, which means that you are visa free. Tier 1 post-study work, that was for foreign graduates who have received a degree from a UK university. Unfortunately, that closed in April 2012. So who are skilled and temporary workers? Tier 2 are skilled workers who have a job offer from a UK employer who are a registered sponsor. We also have an intercompany transfer category whereby if the individual is working overseas for the company, they can be transferred to the UK. Before the points-based system came into effect, we had the Working Holidaymaker Scheme. Do we have anyone who is from Australia or New Zealand here? That has now been replaced by the Youth Mobility Scheme, and that allows 18 to 30-year-olds from Australia, Canada, Japan, Monaco and New Zealand to come to the UK and work unrestricted for 2 years. The government have also announced today that South Korea will also be part of that scheme from June. We also have what's called government authorised exchanges, which is when the points-based system came into operation, there were a lot of employers who found that they couldn't actually fit individual employees into a particular scheme. And the government authorised exchange scheme is where you can get together with a group of companies and seek authorisation from an overarching government body. So if you had a group of IT companies in Silicon Roundabout who wanted to employ people, you could go to the Department of Biz and say, we want to create an IT intern scheme. We want to recruit Indian graduates to do some work experience for 6 months, and then the government department will authorise that. The only issue with that is it's a temporary category. You can't actually employ them long term. We also have a creating and sporting category. That's for your athletes and professional footballers. Also, there are non-points based alternatives, sole representative, which I'll talk about in a moment. If your grandparent was born in the UK or Ireland, you can get a 5-year work permit unrestricted. And we also have a European law option, which is called Van der Elst, whereby you can bring people in from other European Union countries without restrictions. Sole representative is outside the points-based system. This allows, if you don't actually have a branch in the UK or representative, you can actually come over as an individual and set up the company in the UK. The only restriction is you can't be a majority shareholder of that company, and you have to be a senior member of the company abroad. You have to have full authority to take operational decisions. Once you have that visa, you are allowed to live in the UK for 2 years, and then you can seek an extension for 3 years. There is an English language requirement, and that is basically, it's kind of like a GCSE stroke A-level equivalent. So if you did want to sponsor a non-EEA national and all the other routes weren't available to you, you have to register as a sponsor. That involves having the wonderful UK border agency coming to visit you, and they will assess you in terms of your compliance and whether you can be considered to be a lawful and compliant sponsor. Now, Michelle and I work together a lot on training, and this is where sometimes, unfortunately, immigration law and employment law conflict. Because the UK border agency require you as an employer to carry out a number of functions that breach the Data Protection Act and breach confidentiality. One of those conditions is that when you recruit a overseas national, a non-EEA national, they want to see the CVs of all the resident workers you actually rejected. Now, as Michelle mentioned, you shouldn't actually be working out who are resident and non-resident workers through the recruitment process. So as an employer, you are caught between a rock and a hard place. You have Michelle telling you you have to go through the recruitment process nationality blind, and you have the UK border agency saying, I would like to see an Excel spreadsheet of all your resident workers, the interview notes, and why you rejected them. Because the legal test is that you must employ a suitable resident worker. Not the best, not the brightest, not the whiz kid. If they are suitable, if they meet the minimum requirements of your advert, but you liked the American who just, his personality was better, if you employ the American, the UK border agency will say that you've employed that American unlawfully. However, Michelle will say something different to you. You will be inspected by the UK border agency. We are getting 3 phone calls a week from our clients who are receiving on-the-spot visits. Once you are a sponsor, you can be visited at any point by the UK border agency. Once you become a sponsor, you sign away all rights for the UK border agency to come into your offices. They can come in without a warrant, they can examine your HR files, they can take your computer systems away, they can examine emails. The last audit I went to, they interviewed 10 of their migrants. It took 4 hours. They were hauled out of their offices and they were interviewed one by one. That is how serious immigration control is going at the moment. And Olga mentioned, you know, Eric was frightening her. I'm going to frighten you even more. Immigration, the UK Border Agency at sometimes can be a shambles. It can be incompetent. But when they get things right, as employers, you need to watch your backs. Before coming here today, we received a call from a British company who an American employee had rocked up at Heathrow yesterday evening. She told the immigration officer she was coming here on holiday. The immigration officer thought that was a bit strange. Holiday for a month, delved a bit deeper. Well, actually, I'm here on business. Well, what business are you doing? A few meetings. Well, where are the meetings taking place? Of course, she was lying. He went on, he did her bags to find the email from the Human Resources Manager saying, we phoned the UK Border Agency, they've told us you need a work permit. Just lied to the immigration officer on entry. She was detained last night in a detention centre and she's now back in the USA. She is banned for a year, if not life. She is now probably going to sue her employer for telling her to come to the UK and lie. The individual who wrote that email, the UK Border Agency now have their details, and they will probably have a compliance visit in the next few days to see whether they are employing any other unlawful Americans. It is quite serious. We have data sharing between government departments and we also have electronic borders. And once you become a sponsor, you are signing up to a very, very onerous compliance regime, so it shouldn't be taken lightly. As I mentioned, you can only employ people from outside the European Union if it doesn't displace a suitable resident worker. Now that means that if you have a resident worker that you don't like, you cannot put them through a performance management process and then recruit an American or an Australian to replace them. What is the minimum threshold for Tier 2 General? It was NQF level 4, which was sub-degree level. On the 16th of June, which is tomorrow, it will be NVQ level 6, which is degree level. There are two types of certificate of sponsorship that you can issue. That's a new term for a work permit. If you pay an individual over 150,000, there's no resident labour market test. You can just employ that person. Any salaries under 150,000, you have to advertise a job in Job Centre Plus for 28 days, and you also have to advertise in a particular medium as per what is called the Code of Practice. Each occupation in the UK has what is called a SOC code. That describes what the job does and also where you should advertise that job if you need to recruit a non-EA national. Before last year, most people coming in under Tier 2 General after 5 years could apply to stay here permanently. The government feels that is unfair. They're now saying that people who come in under Tier 2 General, the maximum leave is 6 years. And after 6 years, the vast majority of people should go home. You can apply for permanent residency after 5 years, but there is a minimum salary threshold of £35,000. The government have also introduced what's called a cooling off period, a bit like the H-1B visa in the States. There will be a 1-year exclusion period from the end of every Tier 2 visa. So if you don't extend your visa and you happen to go on holiday for a weekend, you can't come back to the UK for a year in order to work. So it's really important as employers that you know where your migrants are at all times of the year if they're going on holiday. Tier 2 ICT is the same. There are 3 subcategories. Established staff if they've been working for you for 12 months or more. Intercompany transfers can only work for you for 5 years and then they have to go home and there's a 1-year exclusion period. Skills transfers can only work for you for a year and graduate trainees can only work for you for 6 months. There are 2 types of intercompany transfers. Short term, where if you pay them a minimum salary of 24,000, you can have them for a year. Long term, if they're paid over 40,000, you can have them up to 5 years. But remember, there is a cooling off period of 12 months from the end of your individual migrant's visa. There is a quota. The quota hasn't been filled at any point since the 6th of April 2011. It's an online process and it's done on a point system. And the minimum points threshold is 32 points. So if you've completed the resident labour market test and you're paying a salary of 20,000, you get 32 points. You will be issued with a certificate of sponsorship. And as Michelle mentioned, a lot of the issues that we have is when we tell employers that they can sponsor an individual, and they say we want to pay them 25,000, the SOC code says that you have to pay them 30,000. And the issue then arises is they want that individual. They want that individual to come in as soon as possible. Do they pay that person 30,000 when all their British workers are being paid 25? because you have reverse discrimination issues. You are paying a migrant more than the resident workers, where usually it's the other way around. It's not resident workers being undercut, it's migrants being paid more. So we have a very, very different scenario now where migrants are getting higher wages than resident workers. Michelle mentioned Osborne Clark. Osborne Clark was a law firm, and Mr. Purohit was an Indian national. He actually had a visa under Tier 1 post-study work, and he applied for a training contract as a lawyer. And they said, no, we're not going through the work permit process, it's too onerous, we can't be bothered. So he took them to the employment tribunal, and this is what they said: as far as possible, selection should be purely based on merit. Work permit issues should only come into consideration at the later stage of selection. So if you go through the recruitment process and the candidate